parent disagrees with the individualized educational program recommended by the Department of Education, or if the individualized educational program mandates are not being met by the school district, then a parent may want to challenge the Department of Education. They can do that by filing what's called a due process complaint, also known as an impartial hearing request.
A due process proceeding begins with a hearing request. And if you're wanting to know where to go as a parent to know how to get that hearing request going, you don't need to be represented by a lawyer. The system is set up so that a parent can represent themselves in what they call pro se fashion. Unfortunately, in my opinion, and I think I have colleagues who agree with, it is hard going through these impartial hearings on your own. So to the extent, in my office, like I said, we provide, or Steve said, we provide free legal help for families of low income. It's difficult, but just know that the impartial hearing officer, the person who runs the hearing, is supposed to ensure that you're provided a fair and equitable opportunity to present your child's case. You can go on the Department of Education's website and type in impartial hearing, and you can get information on how to get the form hearing request and instructions. I'd like to just kind of take a hypothetical, and then we can kind of use that as the material to walk through the due process proceeding. Johnny is a kindergartner, and Johnny's IEP for kindergarten mandated one-to-one, that is one teacher teaching him, special education teacher support services after school, otherwise called SETS. I think most of us have heard the term SETS, special education teacher support services, after school at home, 5 hours a week. Johnny got that all throughout kindergarten as mandated in his IEP. For first grade, the Department of Education reconvenes an IEP prior to first grade and terminates it, terminates that program, much to the parent's disagreement at the meeting. Parent disagrees with the resulting IEP recommendation that stopped that service and files a hearing request stating that the parent disagrees with the termination of the home-based sets and requests that the service continue for the coming first grade school year. Okay, so that's filed. That is sent to 131 Livingston Street in Brooklyn, which is where all the hearings take place. Once the parent files that hearing request, there is what's called an automatic injunction that requires that the Department of Education continue those home-based services during the course of the due process proceeding, which can be a long time. It's called otherwise called the stay put rule or pendency, an enormously powerful right that parents have that allow the service that they are wanting to continue while they litigate bring their claim in an impartial hearing. Maintaining the status quo. It's to allow the child to stay in what's called the then current placement to avoid a disruption in that student's schooling while it's decided whether the termination in this particular case, hypothetical, is appropriate. Again, the general principle is the district may not unilaterally change the child's placement without an agreement by the parent or the impartial hearing officer's decision. What happens after the due process complaint is filed? An impartial hearing officer is assigned to the case. I'll speak about that in just a second. And a resolution meeting, a mandatory resolution meeting, is required to take place. Your parent is entitled to receive a notice of a meeting that is designed to try to settle the case with someone from the Committee on Special Education or the more centralized office, gets it out of the immediate school environment that the parent has been dealing with and into a more removed Department of Education representative to see if can we settle this without going to hearing. What will result is either a full resolution, which is like a contract, both sides will sign. Yes, Department of Education will provide 5 hours of home-based services for Johnny for his first grade school year, and both sides will sign it. And if that takes care of all of the concerns in the IEP hearing request, then you don't have to go to hearing. You get what you want. The parent gets what they wanted. If it is a partial resolution, the remaining issues that are involved will go forward to hearing. Many times you don't agree to anything. There's a stalemate, and the matter is then set for a hearing. an impartial hearing officer is assigned. Who is an impartial hearing officer? They are not an employee of the Department of Education. They are independent, admitted to practice law in New York State, and their authority is to decide the facts based on the evidence and the testimony of witnesses as applied under the law, and render a written decision which is binding upon both parties unless appealed, parties being the parent on behalf of the child and the Department of Education. The Department of Education is represented in this kind of situation by oftentimes by a layperson who is oftentimes someone like a social worker or a school psychologist, and sometimes they're represented by a lawyer. That 5 days before the hearing takes place, and you'll get notice. Parent gets notices from the hearing office all along to let the parent know when there are particular deadlines, when the hearing is, etc. 5 days before the hearing starts, each party exchanges documents. So you get to see what the Department of Education is going to put forward to defend its case, and the department gets to see your information and evidence that the parent is going to put on to justify their claim. What does the hearing look like? The hearing is like a mini trial. There's a court reporter that records the entire proceeding and drafts, develops transcripts, written transcripts that indicate what was said at the hearing. The parties are, again, the parent and the Department of Education submit evidence and documents. The parent can call witnesses to testify, call the child's therapist, call the child's doctor, anybody that the parent feels has an opinion that they want to have on the record to talk about to justify what it is that they're going forward to obtain. The school district usually goes first to say why its program was appropriate, and the parent then will follow up as to talk about why it's not appropriate and what resolution the parent seeks to obtain. Johnny should get the 5 hours he needs the 5 hours per week of home-based sets in order to make meaningful progress. Then the hearing officer writes a decision due within 45 days of the closure date, with certain exceptions if extensions are needed, and based only on and the hearing officer's decision is based only on the documents that are in the record, that are admitted into the record, the evidence, and the testimony of the witnesses. Anything said outside of the proceeding, anything that happens outside of that proceeding doesn't exist with respect to the claim that the parent brought. So it's enormously important that anything that the parent wants to say to justify his or her claim is brought at that impartial hearing. The ensuing decision of the hearing officer is binding upon both parties unless it's appealed. If you or the school district are dissatisfied with the hearing officer's decision, the hearing officer's decision can be appealed to a second administrative layer of review, which is called the State Review Office. A state review officer will review the record. The parent and both parties have an opportunity to provide written arguments explaining why the hearing officer's decision was incorrect and why they're justifying what it is that how they think that the proceeding should have come out. And that has to be done within a particular timeline, 25 days from the date that the impartial hearing's decision was entered. And the state review officer will then issue a final administrative decision within 30 days, typically. I think 30 days is the deadline, from the date that the request for review of the SRO is received, and that SRO's decision is appealable to court, federal or state, whichever is chosen by the appealing party. And that can go all the way up to the Supreme Court. So it's not unusual. I'm not saying that every case does this, because they don't, but the inevitability can be, if you disagree with what the impartial hearing decision was in the SRO, State Review Officer's decision, it can take years. But the due process proceeding from the administrative point of view is designed to try to provide as expeditious result as possible, so that it can get resolved at the lower level before having to go into federal court if necessary.
It probably is recommended to try to find representation to go into these hearings, because they have become more and more like a real trial, and it's very difficult. Even with my clients, when I go into these hearings, they have a lot of emotion and a lot of stress and anxiety attached to what's happening, and I could just only imagine if they went in there on their own, and it's very daunting. I think if you do go on your own, it is important to remember to have your evidence. So you want to make sure that you have maybe experts, like the child's psychiatrist. I mean, and a lot of this depends on your individual case. What it is you're actually trying to do with this impartial hearing. But certainly the hearing officers want to have documents that help support your case, and they want to hear from people who are not connected to the child in a personal way, but who are either treating the child, who are providing services to the child. They want to hear from them, and most of the hearing officers will want to try to do what's right for the child. So if they have enough evidence, they will provide write an order giving you what it is that you're looking for. So I think it's really important to keep that in mind, because it's very difficult to get experts to testify. So if you're trying to get your child's doctor, and I know that's really they've got a very busy schedule. They don't get paid for this. The law does not allow for fees for expert testimony. So it can be very challenging. So that's something maybe you might want to think about beforehand. If you wanted a teacher to testify, you could request a subpoena in those situations to make sure that they're available to testify. I think it's also important to understand that in this due process hearing procedure and process, parents can actually ask for mediation first before actually going to an impartial hearing. So that's something worthwhile to consider, because mediation is actually a structured setting where you will go to a mediation center, and a trained mediator will work with you and the school district to see if you can come to an agreement over what it is that you disagree. And if you don't come to an agreement, you then have every right to then go to a hearing. So doing mediation may actually be very helpful if you're going it alone, because this is sort of like a dry run. You can sort of hear their arguments and know better what to expect. Also, if you do come to an agreement at mediation, that agreement is going to be put down in writing, and that's an enforceable contract. Okay, and you can enforce that in court. So one other thing I think, in addition to mediation, is meditation. I think it's important, for you as a parent to not be so stressed and not be so anxious about this process. And you have every right to be, because this is your child's future, and you have so much invested in this. But it's also, you want to be as involved and as clear-minded about this as possible. And I think taking that step back, making sure you have that self-care is really important.
I think something as simple as if a parent knows that they disagree with the recommendations right after the meeting, they should write a letter stating that and asking for the team to meet. Because like these folks have mentioned, it takes a great skill to be able to have the time, the command of the language and understanding of the law, and the ability to understand the technical aspects of the law to frame the ask to file for an impartial hearing and represent yourself. Many times parents reach out to us about these forms, and we, stop them and ask them to tease out what they're really looking for. And the majority of times, the issues can be resolved at a school level. And I think something else that we don't talk about is the value of parents communicating with school staff, because a lot of advocacy is about relationships. And so if parents have relationships with teachers, therapists, and administrators at schools from the beginning of the school year, sometimes it helps. It doesn't always help. And I want to say that, I've been at this not very long, about 7 years, and I do this full time, and, had to get some help for my own son because I didn't feel confident about what needed to be done from a technological point of view and the lawyer's fees. And what we were asking for was just for the services to be implemented as the IEP was written. It was as basic as that. It was a speech mandate that really was assistive technology, but the data management system didn't know how to document AT on the IEP. So the DOE just pushed back and said, we can't do it, even though it was being done. And we were concerned that it wasn't accurate, that it wasn't converted, because should my son go to a different school, we needed that service to be implemented as assistive technology, not as speech. So I think there's other steps that can be taken before we get there. And just something for people to think about from a systemic point of view, that there's about 250,000 students with IEPs, and 100,000 of them, actually it's more, it's almost 50% of students self-identify as Hispanic. And we have language barriers, income, housing, employment. We have all these other aspects and social constructs that feed into this. So it's very, very few parents that could do this on their own.
Yeah.